Hello everyone. Today we are going to discuss on a case for business law. Subject code HA3022. I'm Anubhav Pekral, student number EMV21770 from Home Institute. So being a group member, I have three more members in my group who are Santosh Nyopani, EMV21641, Aashish Karki, he is the group leader, is student number EMV21763, and Vivek Lama, RIA2419. So my group have choose the case named RTA versus Dictator. According to this case, we have a table contained of introduction, the fact of the case, issue raised by plaintiff and defendant, the argument presented by both parties, the judgment of the court, the decision of trial judge, appeal court decision, RTA liability, high court decision, implementations, and lastly references. So in this case, there was an incident of 14 years old boy named Philip Dictator who dropped off from the bridge of Olamba River up to the height of 9 meters straight into the water and faces catastrophic personal injury. This was the first case was filed to the court. I would like to present as a plaintiff in this court. The fact of the case. According to this case, the boy named Philip Dictator drive off from the forecast bridge was a 14 years old boy and faced catastrophic personal injury. The location was very famous for the tourists, where many youngsters are rapidly jumping and driving off from the bridge. Even Philip Dictator has spent his holiday in that location. The boy didn't know the depth of the water. The water suddenly dropped at the bank of the sandbar and the water was deep in the channel. Philip's head stuck on a sandbar and he dropped from the bridge. Even there was a sign which disallowed driving and the sign in words disallowed climbing on the bridge. The sign was ignored by Philip after also seeing Walker, Stanton and crowd Bury 2030. Issues raised by plaintiff and defendant. The RTA has a clear awareness of being rapidly jumping off the bridge. The RTA tried to prevent themselves and confer with police. True, RTA replaced all sign with a written messages like no jumping or no diving, but seems no effect of such messages so far, as there was no incident before related to driving off the bridge. That was the first shocking case for RTA. So now I'd like to call Santosh Nyopani to cover the remaining case. Thank you.
Hi, I'm Santosh Nyopani. My student number is EMV21641. Today I'm going to talk about the argument presented by the both parties. Now let's listen to the argument from the plaintiff. My client, Mr. Philip Dictator, has to face many physical injury. He's going to be in a wheelchair to walk due to internal injury of his spinal cord. He's just 14 years old and he still has hope to be cured soon. He needs too many medical and other tests, which needs huge fund. First of all, let's discuss if the RTA is liable. It gives birth to the two questions. Was it possible to prevent this foreseeable and was this accident stoppable? In this bridge area, there were not effective warning signs to prevent young children driving off the bridge. There is no preventive fence to prevent young children from jumping off the bridge. This kind of accident need to be prevented by using warning sign or fence over the bridge. Now let's hear the argument from the defendant. My client, RTA and the council has applied all the preventive measures to reduce such incident. It has used pictograph as well as written message to demotivate road user to driving off the bridge. As the RTA does not own the duty to stop road user from driving off the bridge, after knowing the fact the people are not adopting logical safety measures for the safety. The user also need to perform and adopt all the safety measures for themselves. Now let's talk about the judgment of the court, which includes the decision of the trial judge. The judge of Supreme Court found that both the defendant party, that are council and RTA negligent job and team 2015. The judge was satisfied with both defendant has performed enough duty of prohibiting driving and jumping off the bridge to warn visitor from jumping off the bridge. The judge found that defendant ignored the fact that visitor disregard sign and written message. Both the party must contain duty of care towards visitor or the general public. The judge found RTA has not properly followed the duty of care and shows negligence while forming danger messages such as shifting sand, danger, and variable depth. His Honor found 80% negligence responsibility to RTA and 20% to the council. As the RTA had full control of the bridge, more access to the fund from the bridge connection. At the first place of the danger, the bridge, but the RTA failed to modify the structure of the bridge instead of ineffective result of the pictograph of the message. Now my friend Vivek is going to talk about the rest of the judgment of the court.
Hi, myself Vivek Lama, RI 2419. As of the appeal court decision, the RTA and the council also appealed against the trial judge finding guilty in the negligence. Plaintiff has to face the risk of serious spinal injuries due to the act of dive off the bridge. It was an objective standard of 14-year-old person who dived off instead of having good knowledge of the location and condition of the bridge. Even aware of the area and seeing pictograph sign prohibit diving off the bridge, which can lead to serious injuries. As per the RTA liability, there are many evidence that the RTA has clear knowledge that youngster was frequently diving off the bridge. RTA need to face all serious risks of devastating injuries to the plaintiff. Court judge found that the pictograph sign for the prohibition to dive were all failed. According to the court decision, RTA needs to perform standard of care higher than any other authority which control land which natural feature from public to danger. The triangular top of the fence can prevent plaintiff from driving off, and pull-tight fence can combine with it can probably help to reduce such accident. It has breached its duty of care in the safety of the visitor, so it needs to perform some inconvenience act and further need to be committed towards the safety of the visitor. But the court also found that plaintiff is 50% responsible for his injury. Coming up to the High Court decision, His Honor found that the road authority has performed reasonable care so that the road found safer for the users. The users also need to adopt all safety measures for themselves. In the High Court judgment, His Honor do not found RTA need to owe more obligation towards the careless users as compared to careful diver one. The decision of judge include that an obligation to prevent harm must take consideration of the obligation to perform reasonable care. His Honor stated that from simple to complicated case, one thing is a basic principle that duties of care differ from the content, only to discharge by performing logical care. This court in favor of the RTA as the fact the RTA has applied the more preventive measures to be taken from the individual who jumps off the bridge. His Honor argued that if a contrary approach applied, the plaintiff is self-responsible for all the incident and he ignored the majority of the warning sign. Now I would like to further pass on the information to Aashish.
Thank you, my friends, Sanur Bakurim, Santosh Nupani, Vivek Lama for all the informations. Conclusively, the various tests needs to be applied to know required level of care in response to a risk of injury. The decision affirms approach taken by High Court needs to be considered in the level of what a logic person would perform to avoid injury risk. The concern was why the court decided in favor of the party that I have selected. Court decided in favor of the party that I have chosen as plaintiff's side is stronger than other parties' case because the defendant has not adopted an effective measure of warning sign, symbol or pictograph to prevent young children from diving off from the bridge. It has not used any fence or bar to minimize such incidents at the first place of danger. As RTA had full control of the bridge, more access to the fund from the bridge connection, there seems a carelessness of the RTA in developing an application of the warning sign, preventive tools and techniques, though having the full knowledge of happening such incidents time and again in the past date. Due to such carelessness of RTA, plaintiff has to face such catastrophic physical injury and huge amount of expense for treatment. If my chosen party lost the case because of the defendant party has a strong argument as they have used many pictographic or warning sign in the area of bridge to prevent young people diving off from the bridge, despite RTA has performed all duties and responsibilities that can prevent such incidents. RTA doesn't owe the duty to stop road users from diving off the bridge after knowing the fact that people are not adopting logical safety measures for their safety. We have gathered all of these informations from JORC 2014, the amount of consolation compensation in road traffic accident, accident analysis and prevention 85 1 to 12, self-explaining road and situation awareness, safety science 56 18 to 28. Thank you for being with us. Thank you.